Imagine you're at home minding your own business when suddenly you hear, "Police, welfare check, open up." You have no idea what's going on, but you've watched my videos before and you know you have a constitutional right to remain within the privacy of your own castle, so you choose not to answer the door. The cops, they keep knocking and they say they are coming in. I'm Jeff Hampton, the people's lawyer, and in this video I'm covering the new Supreme Court case that changed the Fourth Amendment and made it easier for cops to get into your home without probable cause. Stick around to the end because I'm going to show you how cops use this new welfare check to get into your home without probable cause and what you can do to limit cops from getting into your home. The Fourth Amendment to the United States Constitution is supposed to protect each and every one of us from unreasonable searches and seizures. In fact, the Fourth Amendment specifically states, "It is the right of the people to be secure in their persons, houses, papers, and effects, and it shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." Now, we all know that over the years that cops in the Supreme Court have found ways to erode that right of privacy and protection, but your home, it's supposed to be different. Traditionally, up until now, the system's supposed to work like this. Police suspect something, they write it down. They go to a judge says yes or no. Then they're able to enter with a valid warrant. The judge is the circuit breaker. They are the ones that help determine, is there sufficient probable cause here to warrant an officer invading your privacy and your home? But there's always been one lever that the government can pull. They can try to claim there's an emergency. Because after all, if someone's bleeding out, no one wants a paperwork-first constitution. And therein lies the problem with this new Supreme Court case that was just issued in January 2026 that defines that emergency exception continues to expand so that now cops don't even really need probable cause to get into your home. So here's the setup and exactly what happened with William Case. A woman calls 911 about her ex, William Case, in Montana. She tells dispatch he's threatening suicide and might have shot himself. Police show up. They knock on the door. They yell into an open window with no response. Then they look through windows and see a few details that, well, depending on your life, could be normal or could be spun into a crisis. Empty beer cans, an empty handgun holster, and a notepad they wanted to interpret as being a suicide note. Now watch this. Here is the phrase that should change the way you see the term emergency aid or welfare check. Police claimed there was an emergency here, but they didn't kick in the door immediately. They called their chief, they conferred with him, they worried that entry might spark a confrontation, even though they think he might have already shot himself. So what did they do? They geared up. Ballistic shields, long barrel guns. They were ready to force their way in. But get this, even though they claimed there was an emergency that they absolutely had to look into, they waited a total of 40 minutes from the time they first arrived before they ever made their way into the door. So the first lesson I learned that came out of this case is that when cops claim there's an emergency, even if it takes them 40 minutes, it's not really that seconds count. It's all about the story they come up with after the fact. If the police can explain some believable emergency story that justifies coming into your home, then the need for a warrant was unnecessary because they were just doing their job. But back to the facts of the case. Inside the house, Case is in a bedroom closet. He throws open the closet curtain holding something that looks like a gun. An officer shoots and injures him. A handgun is found nearby. And Case ends up being convicted of assaulting a public servant. So imagine the cops entered the house claiming they were there for an emergency rescue, but it only ended in a prosecution. So what did the Supreme Court actually decide here? They said police can enter your home without a warrant to render emergency aid if they have, quote, an objectively reasonable basis for believing someone inside is seriously injured or facing imminent serious harm. Sounds responsible, right? But here's the critical part. The court said that it does not require the cops to have probable cause. And the Supreme Court didn't say it casually. They literally changed the standard from probable cause to an objective, reasonable belief. What does that mean? Exactly. And the problem is the court didn't really define it either. When Mr. Case challenged the Supreme Court on this claim of the standard, the Supreme Court basically responded that the standard means exactly what we say it meant. And we don't need any further explanation. This is critical and it's very important. And I have to ask you, when it comes to the Fourth Amendment, is the interpretation of this going to mean the Fourth Amendment is essentially dead because the Supreme Court now says no probable cause is required? That line by the Supreme Court is a bomb because the requirement of probable cause is in the Fourth Amendment, specifically requiring probable cause. And now it essentially removes all of the essential questions a cop must answer in order to lawfully get into your home. You say, come on, Jeff, is it really that big of a difference? Well, the finding of probable cause forces police officers to answer reliability questions. They have to answer questions like who said what, how do they know, and what was actually verified. But this new standard of objectively reasonable basis, what does that mean? That is now squishy. It's messy. We have no idea what it means, particularly in a situation where some neighbor called 911 or some ex of yours doesn't like what you do or say. So they call the cops claiming you're unstable or emotional. Think about it. Anybody can call in for a welfare check. Anybody can claim, oh, I think he was strange. He might be suicidal. Or, oh, I think he has mental health issues. Which brings us to the real change according to this new Supreme Court case. Under the old Fourth Amendment constitutional standard, judge before entry equals front-end accountability. It stopped cops from just making up things as they go. And they had to see a judge before they got into your front door. Under the new model, the judge only has to be referenced after entry and the cops receive back-end forgiveness. And by the time a judge has, your privacy is already gone. Your home has already been searched and completely tossed. And your life has already been permanently altered. You can't unring a doorbell. And you can't undo the damage once the cops make it into your house. So now that we understand what the Supreme Court ruled, we have to understand why this new standard gets dangerous very fast. The Supreme Court tried to frame this as non-criminal or non-investigatory. It's just nothing but a wellness check. But in the real world, once cops are in your house, two things happen. Number one, anything cops see in plain view turns their so-called "I'm just here to help" into evidence against you and you being arrested. Under the plain view doctrine, once cops force their way into your house, they can use anything they see, anything that might look suspicious, as a reason to escalate the encounter. Once they escalate the encounter, they'll secure the scene, use it as a reason to toss your house, and build a case based on anything they find. And then the next thing that happens, number two, is that the story that cops tell in the police report begins to drift. It always starts with "we're only entering to help," but it quickly turned into "we saw X, we feared Y, we detained Z, we then had further probable cause, and we searched and found more." This is not paranoia. This is exactly how cops are trained to behave when they get into your home. If that's not bad enough, this is where this court decision gets very ominous for millions of people. Justice Sotomayor wrote an opinion, a concurring opinion here, that basically reads like, hey, listen, everyone should be very careful because in situations like this, especially when there's a gun, things can spiral out of control. She then points out something very concerning to me. She says that the risk of escalation is heightened even more because of how common it is for Americans to have guns in their household. And because of this, police may need to use more forceful tactics when they realize that that homeowner could be armed. So think about what Justice Sotomayor just said and how that applies to this objective reasonableness standard that the Supreme Court now has created. Imagine if your neighbor who doesn't like you calls over to the cops and says, "You know what? I've been talking to old Billy next door, and he sure is depressed. And he's a gun collector, I'll tell you right now. Watch out, he's got guns in the house. Who knows what he will do? Even if that gun is legal, even if it's locked up, even if the gun has nothing to do with anything. Now, in the eyes of the cops, because of this court opinion and this new standard, it can become a risk multiplier in the eyes of the cops, which could now justify them using a harder approach with you than someone who chose not to own a gun. Now, I have a problem with this because your constitutional protections should not shrink just because you own something you have a legal right to own. But under this new standard, that's the situation that gun owners may now face if the cops learn, oh, you're a bit unstable, or, oh, we're going to do a welfare check and I think this guy may have a gun. But what if you don't own a gun? What if cops just want to come by and do a quick welfare check? Well, now what we've learned is that welfare checks aren't what they used to be. If you never had a cop knock on your door claiming a welfare check, you might believe it's going to be a soft, casual conversation where he'll check in and he'll walk away. But under this new standard, not necessarily so. Because this new precedent, under this new standard, establishes where, just like Mr. Case had to go through, cops can now show up doing, quote-unquote, a welfare check. And this can easily turn into long guns, ballistic shields, and an armed entry. Oh, and Justice Sotomayor, she added another warning label. People with serious mental health conditions are disproportionately harmed in police interactions. So, if we're going to be brutally honest, we have a collision of realities that are now put in motion by this Supreme Court decision. Number 1, mental health crises are unpredictable. Number 2, police are trained for control and threat response. Number 3, the home is a confined emotional space. And finally, number 4. Now, the entry standard to get into that home is easier than ever to satisfy. You put all those realities together, that's how tragedies happen in living rooms. So this brings us to the ultimate question. Are there any limits to this new standard to stop cops from getting into your front door? Well, when you actually read the opinion, the court just repeats their standard line. An emergency aid entry doesn't authorize a full rummage through your home, but here's what really matters. The protection of your home under the Fourth Amendment was never just about whether cops can get in and perform a search. It is also about whether the government is required under the Constitution to stop at the threshold of your home's front door to go to a judge and get a signed warrant with probable cause supported by facts and affidavit before they can force their way into your house. In Case versus Montana makes that requirement to talk to a judge ahead of time completely optional. So if a cop ever walks up, tries to claim they're performing a welfare check on you, here's some steps you can take to try to protect yourself and limit their ability to get into your home. Number 1, tell your people what to do if you choose to go quiet. Why do I say this? Because a lot of these police encounters for welfare checks start when someone who cares doesn't know what's going on. I know this should seem like common sense, but if you go dark on someone, tell them to number 1, try to call you first. Number 2, call someone else that you both know. Secondly, to reach out. And number 3, call a crisis resource center anywhere else. Because if you call the cops, I'm going to tell you right now, that should only be in a situation they know presents immediate danger to you and not a, I don't know what's going on. So I'm going to call the cops. Number 2, if you own a gun in your home and people know you own a gun, get ready for unexpected police presence. If they show up at your door, assume anytime there's a welfare check, it's about to get much heavier than you thought it would be when you have a gun and the cops have a gun outside your door. Understand there's nothing really holding them back now from forcing their way in. If they come up with a reasonable belief, an objective, reasonable belief, whatever that means. So the goal is de-escalation, not winning the argument. But what if the police are at your door and they refuse to leave? Number 1, start by communicating with the cops before you open the door. You have no requirement to open that door. If you can provide some communication to the police to show them you are not a harm to yourself or others. Choosing to remain silent actually feeds the emergency narrative. So I normally tell people you always have a right to remain silent. But when cops pull this situation where they show up claiming, oh, there's an emergency and we need to get inside, the longer you're silent, like Mr. Case was, the more they can justify barging into your home. If you're safe and you don't need the cops there, you can speak through the door. You can even pull back a window and you can talk to that officer directly. But it does not require you to have to open the door in order to show them that you are not a threat to yourself. In fact, you can say specifically, quote, "It's okay, I do not consent to entry. Do you have a number 2? Ask them specifically what they need to hear from you so that they can close the call. You say, "Officer, what can I do for you to document this situation, that I'm safe, and that you can be free to leave?" And by the way, that leads me to number 3. This is why you've got to record everything, record the entire encounter, and make it crystal clear that you are not consenting for them to come into the home, but that you did interact with them, and show that you are not a danger to yourself or anyone else. And finally, number 4, offer a low-risk verification process to get the cops off your front porch. Step into view so that the cops can see you. Talk to dispatch on the call. Make it clear to them exactly that you are fine and there is no issue going on. And only if absolutely necessary do you go outside to speak to the officers in order for them to understand that there's nothing going on. But by all means, don't take a weapon with you and do not give them consent to enter into your home. Because remember, they came only as a welfare check to make sure you're okay. The moment you stepped outside and shut that door, they have no basis to come into your home because they now have access to you and they can confirm you are okay. But if the cops force their way in anyway, don't resist. Physically resisting is the number 1 thing most police officers are looking for to justify now claiming you are a threat to their officer safety. So instead, you tell the officer very clearly, "I do not consent to a search of my home or my person, and I will not answer any further questions unless my lawyer is present." Case versus Montana may be the 4th Amendment case you didn't hear anything about. Case versus Montana didn't announce that the 4th Amendment was dead. It did something much more deceptive than that. It changed the language under the 4th Amendment so that cops can now use a different standard based on their belief of an emergency to go around the 4th Amendment and find their way into your home. A judge's signature on a warrant supported by probable cause is fundamental to our constitutional rights and is in the plain language of the 4th Amendment to our United States Constitution. But now, in so-called "we're just here to help" calls, cops can make their way into your house, and then judges can say, "Yeah, that seemed reasonable" later. And the final shocking thing I want to mention on this video is that the decision was 9-0, 9-0. It was unanimous, which means what? It sends a clear signal to all the lower courts to open the floodgates. If cops claim there's an emergency, they can enter and seek forgiveness later. So I have to ask you, if your home isn't your castle and the most sacred and private place of all, what is? Speaking of your home being your castle, what if you look to open the door to show the cops you're okay and they shove their foot in your door? Check out this next video where I break down how you can stop cops from shoving their foot in your door and the legal rights you have in that situation. See you over there.